This is the webinar today on Can My Employer Terminate Me During COVID-19? What employers and employees should know. So on the phone today, I have Andre Gaston with me, who owns and manages Gaston LLP. He practices in the areas of employment law as well as criminal law. He's also licensed in Illinois state courts, as well as Illinois Northern and Central Federal Districts. Thank you so much, Andre, for being here with me today to talk about employment matters in the current context of crisis mode that we're in.
Thanks for having me.
And if you all didn't know, my name is DeBarros. I'm going to be your host and co-panelist today. I own and manage the S.O. DeBarros law firm. I also practice in the areas of business, employment, sports, and entertainment. I'm licensed here in Illinois state courts, as well as the Northern Federal District, as well as Wisconsin State Court. So let's just, before we jump into it, we have to give a disclaimer, guys, because we want to make sure that no one construes any opinions of the presenters to be personalized legal advice for you. So you understand also by watching this webinar that there is no attorney-client relationship that is created. All right, Andre, so let's just jump right into it. We are in a time where employers are probably bleeding financially because of the current crisis. And people have been calling me and asking, can I be terminated, right? And so it has garnered me to really think about what employment law really is at its core and how it applies in this particular time to individuals. So before we get into the rigors of what can happen or may happen with the current crisis, take us through the general employment law principles that people should be aware of, whether you are an employer who has employees or an employee yourself.
Yeah, I think that's a great way to start this webinar off. The long and the short answer to that question is that employment law is still the same. We operate from the position that by and large, virtually every employee in the United States of America is an at-will employee. And what that means is that an employer can terminate with or without cause or with or without notice any employee that they want. And that's a very difficult concept for most people to understand, as a employment litigator, getting the calls from people and people saying, well, I didn't do anything wrong. But you could literally walk into work, your employer could tell you that they no longer need you, even if you've worked there for 40 years, and the employer is not required to give you a reason. The laws have been historically drafted in a way to protect employers, and it gives the employers power to hire and retain the people that they want there, only subject to certain exceptions. So your employer can't fire you because of race, religion, national origin. These new decisions are now coming out where sexual orientation is evolving into somewhat of a quasi-protected class. You can't be fired because of pregnancy status or disability status. There are federal and state statutes that prohibit that type of conduct. But other than that, everything else goes.
So when we look at those principles and those exceptions that have been on the books for quite a long time, some employees may believe, well, I'm a woman or I'm a minority and this thing happened to me or someone said this to me, so I must have a case. There is something that's called a legitimate termination, or someone has to be substantially similar to another person. Those are some some principles that we know of, some key terms that we know as litigators that we have to be able to establish to create a reasonable inference that there was in fact some type of employment violation that would support a claim. So talk to me about those particular principles and why an employee would need to be able to establish those things in order to even make a prima facie argument that they have actually been violated in some employment matter.
Yeah. The law, as we understand it, is a very broad, amorphous concept. Employment law is not necessarily built on this huge principle, but it's built on the exceptions. Mm-hmm. And so one of the toughest things to explain to African-American clients, and I'll just use African-Americans as an example, mm-hmm. is that there's a difference between you being fired because you were Black mm-hmm. and you being fired and you just happen to be Black. Mm-hmm. And to go back and address your statement about making out a prima facie case, in order to even allege discrimination under Title VII, you have to be able to set forth certain things simply to get you in the door. That's the prima facie case. Mm-hmm. You have to be a member of the protected class. Mm-hmm. The things that we talked about that are set forth under Title VII and here in Illinois under the Illinois Human Rights Act. If
and you're just not for a member our listeners, Andre, really quick, Title VII, that is our Civil Rights Act.
That is correct. Yes. Okay. And if you can't identify with being in a protected class, then you have no claim, you have no case. Mm-hmm. I often tell my Caucasian male clients that Title VII wasn't really designed for you.
For them. Mm-hmm.
Right, because white males are the most least protected people in the workforce. Mm-hmm. And it's simply because, one, white males typically dictate the terms for employment in most of the companies in the United States. Mm-hmm. So the expectation is you can't really discriminate against a white male because mm-hmm. that person has the ability to go and be reemployed. Title VII was really designed for African Americans who were not being promoted and who were being excluded from employment situations mm-hmm. Historically. And so what Congress decided to do in the 60s is to develop some federal guidelines that afforded African Americans and other minorities and protected classes some protection under federal law. And then ultimately you had the Pregnancy Discrimination Act, the ADA, the Age Discrimination and Employment mm-hmm. Act, and other progeny that they were developed to more specifically address other protected classes.
Okay, so we've discussed the threshold of being a part of a protected class to come in the door and say, hey, I have been violated under this particular title or under this particular act for employment purposes. But once you get in the door with that, talk us through why it's important to establish this similarly situated concept.
Sure. Let's assume that I am being discriminated against based on disability. I have to be able to show that there were other people who were similarly situated as I was, who were treated better than I was. So let's say if I am a cashier and I work in a company that I'm the only cashier and every other person's job is remarkably different than mine. Let's say I'm the cashier and I've got 8 managers, 4 supervisors, 2 vice presidents, and 1 president. And I allege that I've been discriminated against based on disability. Well, I have to be able to show that there was somebody else who occupied the same position or did the same job duties that I did who was treated better. Well, if none of the other people who are working in that company who have the different titles that I just stated, have, if you can't compare apples to apples in terms of title and job duties, you have no claim because you have no comparison. So you have to be able to show other people who are doing substantially the same or similar job as you that were treated better. That's why the essence of discrimination is to show that you have been treated differently. And if you can't show that there was somebody who was doing the same thing that you were doing has been treated differently, then the claim fails as a matter of law.
Right. So keeping that in mind, our general employment law principles, we're going to move into our current crisis now. So we have this new rule that came out, the Families First Coronavirus Response Act, which is a part of the CARES Act, and it puts additional duties on the employers to provide certain benefits or leave for employees, and it also bolsters employees' rights. So under this Response Act, Andre, there is leave that has to be provided under the FMLA, and there's also additional paid sick leave. Why don't you start talking with us about FMLA and generally the confines of what FMLA is now without FFCRA and the importance of why it matters in a response act under the Families First coronavirus.
Yeah, the essence of FMLA, or the Family Medical Leave Act, is it is a federal statute that was enacted by Congress decades ago to address the needs of families, family members who are sick and need to be cared for, or individuals who may have a medical condition that requires them to take leave. Now, what's important about FMLA, and this is probably the most important thing about FMLA, is that it provides job protection for that individual up to 12 weeks in a calendar year. But you have to work at the company for at least a year in order to qualify for FMLA. And so while you have that protection, and while it does protect your job, the important thing to remember is it's unpaid leave. So you can have FMLA where maybe a person has had surgery and they may need to have a significant period of time off. The job cannot fire that person for taking FMLA. The job is protected, but the leave is unpaid.
Thank you. And so under the FFCRA, one thing that is notable here is in the general sense of the rule, you have to work for a year to qualify, but here in the FFCRA, an individual only has to be employed for at least 30 calendar days.
Absolutely.
Right.
And you and I, we've had multiple conversations about this as practitioners and advocates for people who have been mistreated in the workplace. If there were two people who were more excited about the enactment of the FFCRA than you and I'd like to find them. But the beautiful thing about the FFCRA is that, again, to your point, you only have to be employed for 30 days. And what it requires the employer to do is, one, it protects your job, and two, it provides that additional financial compensation that the FMLA does not. So if you are out with COVID and you have symptoms, then your employer is required to pay you, a certain number of weeks at 100%. If you're taking care of a child who is out of school, then FFCRA has provisions where you can get 2/3 of your pay and you can stay at home with your child or some other person who has COVID-like symptoms. So the distinction between the FFCRA is the financial compensation component compared to the FMLA, which we've already discussed does not have a financial component. It provides protected leave, but it does not provide any pay. And there's a shorter window of time that the employee has to be employed under the FFCRA, which is only 30 days compared to the FMLA, where an employee has to be employed for a full calendar year.
Individuals now, if they are sick or having to take care of someone else, or taking care of their children because of school closings, why is this act and this particular portion in the act important at this particular time based on what an employee probably already have in operation with their employer?
Yeah, I think I think that it's important to understand and to give Congress and both sides of the aisle a lot of credit in enacting the FFCRA. I believe that for the first time in a really long time that Congress got it right. And I think that the financial component of the FFCRA was necessary in light of the rapid spread of the coronavirus. And what it did was the act addressed the financial piece that which incorporates the budget or the huge financial insertion by Congress into the economy to be able to help people in the short term. What's important to note is the FMLA is not going to go anywhere. That act has been around for a long time. FFCRA, which addresses the coronavirus more specifically, is only going to be around until the end of the year unless there is congressional approval to extend the act. But what it basically did was Congress provided a stimulus package for businesses to be able to allow individuals to be covered for short periods of time with pay to address these medical issues that may be going on individually with the employee or with one of the employee's immediate family members.
So there may be some claims to start either rolling into federal court or post-COVID with individuals who are being forced to file unemployment versus being provided leave under this act, whether it's paid sick leave or extended FMLA coverage.
Sure. Yeah, I think that there is a lot of danger for employers now. And I certainly think that it's going to be wise for a lot of employers to reach out and seek competent counsel to discuss these issues and to understand the interplay between FMLA and the FFCRA. Because there are key distinctions between the two acts. And so, for example, if you had an individual who was already getting FMLA, the coronavirus hits, and let's say the employer is bleeding financially, and they end up terminating that employer during this period of time, there may be a cause of action for an unlawful violation of the FFCRA as well as FMLA. Because if you terminate that person on the heels of them taking FMLA, then I think you'd certainly be able to make out a prima facie case for a violation of the FMLA. And then you'd also be able to file for an action with the Department of Labor and seek some type of relief under the FFCRA as well.
And I can just see an employer defense attorney filing a motion to dismiss claim by stating, hey, you don't meet the threshold of an employee who's qualified under FMLA leave, even if you receive extended leave because you didn't work for at least a year. But we know from the FFCRA, if you've at least worked for 30 calendar days, then you would meet that threshold to be able to potentially succeed on your claim.
Yeah, so yeah, I think you're exactly right. I think it's pretty much a gotcha position either way. On one hand, where a individual may not have worked enough to qualify for FMLA, it's hard to imagine, absent someone only working for a couple of weeks, that there would not be some exposure to liability under the FFCRA if in fact the employer turned around and terminated that person. And the difficulty for employers at this point is balancing the needs and the finances of their company with this new federal law. Congress had to do something because the COVID virus is here and it has affected the economy in such a great way. But at the same time, where businesses are still trying to continue to grow, the undercurrent of potential liability is there in the event that they start getting rid of employees. It's also important to note that under the FFCRA, there is an exception. As a general proposition, the FFCRA covers companies with 500 or less employees. Mm-hmm. There are certain exceptions, and I think that smaller companies could apply for an exemption if they have a business with 50 or less employees and somehow the business would be adversely affected financially moving forward. But that's a dangerous proposition too, because I can't imagine that if a business is trying to be exempt from the FFCRA and their motivation is that they're going to lose money for a couple of weeks, that's probably not going to do it. They'd probably have to show some type of irreparable harm economically to the company over a long-term period of time. So there's danger in that too.
Right. And speaking of thresholds, I do want to just make a point, like for an employee to even qualify under the FFCRA, you basically have to have some form of difficulty in working, being unable to work on your employer's premises or being unable to telework. And so one of the examples I shared with you the other day was, if I work in a factory, I can't do my factory job at home. So that means I can't work at the factory because of the crisis, and I can't do that job at home because I don't have the equipment and all the things set up to properly do it from home. If I worked at a hotel, I may be able to go and turn over the rooms in my own house, but how does that benefit the hotel? So I can't telework either, right? And so those particular examples will fall under qualifying reasons of why an employee may need this type of leave under the FFCRA. But I want to throw a question out there to you, because even if you had 50 employees or less, where you probably didn't come into the confines of the FFCRA, there may be some type of issue if you terminated someone's employment along the timeline of this crisis, right? We talked about this, and I'm trying to find the words, but the timeline may be a little iffy in the sense of, did you fire me for a legitimate reason, or did you just terminate me because you don't want to provide proper leave?
Well, you know what? I know exactly where you're going. And I just had this thought a second ago. I think it's a great point. The timeline is going to be horrible no matter what. If you're getting rid of an employee during this COVID crisis, absent that employee pretty much showing some for cause, just doing something that you'd be able to document and get rid of that person. But what it also makes me think about too is that we've talked a lot about the FFCRA and FMLA. You could run into an issue where you might be able to make an argument as a practitioner that if a person is suffering from COVID symptoms and those symptoms are disabling, are determined to be a disabling condition, you could have liability under the American with Disabilities Act. So if a
Mhm.
person is out sick as a result of COVID and can't come to work, and it's pretty easy to define what a disabling condition is, you simply have to define what a disabling condition is under the act. But if that employer fails to make a reasonable accommodation,
Mhm.
and that might include the person working from home, to your point, it might be giving that person extra leave. It might be, allowing that person to come in at a different time to be able to complete their work. If there is no reasonable accommodation made, it's hard to imagine that you wouldn't be able to make out a prima facie case for a violation under the ADA.
Now, taking that into account, let's flip things on its head, because what if we have an employee who was already on leave and probably remained on leave for however many more days or weeks? What would that do to the employee's potential case?
Probably help it, because if that person is already on protected leave and the company turned around and fired that person, then not only would you have potential liability under the FFCRA, FMLA, or the American with Disabilities Act, you probably would be able to bring an action against the employer for retaliation for engaging in a protected activity. So, there's the added layer of exposure anytime that you're going to get rid of an employee who has protected leave. The FFCRA just probably opens up the door for more damages against the employer. And we talked about this too. If I'm advising an employer about how to deal with an employee who is already on protected leave, I'm telling him to leave that employee alone. If there's some way that you can provide, you need to satisfy the paid leave portion. So if they're going to get 2 weeks of pay them that money. And then you need to figure out if that person has any unpaid protected leave, allow them to take that unpaid leave. That way you'd be able to document that you've done everything that you could possibly do to help that employee within the confines of the law. And I think that's the only way that you would be able to avoid any liability.
That takes us into the best practices. And Andre, you made a great point right there with employers. They definitely do need to make sure, if not any other time, this is probably a great time to make sure that you're documenting what you are providing employees in terms of benefits and their paid leave. Because one thing that can get an employer caught up into federal court is not being able to address any allegations against them just because they don't have proper recording records.
Absolutely.
Yeah. So give us another tip on what could be a best practice tip for an employer in terms of, getting their house in order, so to speak.
Right. Documentation. Document whatever leave that you're providing. Make sure that you have your financial records, payroll records in order, as well as any leave that has been taken by the employee. You have that documented, and document a process that the company is taking in order to comply with both state and federal law. And the easiest path to take for employers, I believe, is to simply reach out to someone who actually practices employment and labor law. Even during this webcast, sometimes I have to pull myself back because we're so accustomed to reading case law and statutes and drawing distinctions that the layperson doesn't necessarily know what we're talking about. But it's a very simple process in terms of protecting yourself. Some of the most difficult cases that I've ever litigated in federal court are the cases where the employers have really documented everything. So if they're going to get rid of an employee for performance issues, they are going to have a performance improvement plan was given. They're going to set up weekly meetings. They're going to be able to document the deficiencies in that employee's performance. And so when an employer has done that, it doesn't make the claim impossible to prosecute, but it certainly makes it more difficult to prosecute when you are alleging that your employer has been unlawfully terminated, but the employer has at every stage of the employment documented what they believe are legitimate non-discriminatory reasons for having that person discharged. So even if the employer doesn't win outright immediately, it creates a question and a pushback. And what it does is it gives the employer leverage to be able to negotiate a settlement that would be less than an employer who did not document adequately the employee's situation.
Right. Very well said. What's your advice in terms of best practices for employees, not just during a crisis, but in general?
Yeah, I think that if we're just, employees have an obligation to be good employees too. So if we're talking about an employee taking leave under the FMLA or under any other act, make sure that you are submitting your request to your employer. And that can be done via email. It could be done in writing. But if you're going to submit something in writing, you need to make a copy of it. And you need to have proof that you actually submitted it so that the employer doesn't come back and say, hey, you asked for this leave, but you never gave us anything in writing. So you definitely want to have all of your ducks in a row by providing written documentation and proof that you actually submitted it. And you need to make notes that you submitted documentation to X employer at this particular time. If you don't get a response back from your employer, you need to go back and submit in writing again and say, hey, on this date, I submitted this documentation to you. I never got a response back about this question that I had. And time and time again, where employees tend to mess up is they will allege that they've communicated something to the employer, such as a complaint. Someone's complaining that they've been unfairly treated, but I will ask, well, how did you submit that? And they'll say, well, I just said it. Well, of course, the employer is going to come back and say that we never got a complaint. So the easiest way to be able to protect yourself is to have written documentation to support any allegations that you might be able to make against the employer.
I agree. And I do want to add to that, because in this practice of law, and especially in the practice of employment litigation, employees will come with an idea of, okay, maybe I have a claim for this particular issue, but they're no longer working on the premises, and they're trying to recall names of individuals who were there and who were witnesses. It's equally important not just to document requests that you're making, but people, their names, their phone numbers, descriptions of who they are, because at the end of the day, that's going to help to illustrate the substantially similar situation, especially if you know of people who were treated more favorably than you. If there are additional employment claims that you can raise alongside any violations of paid leave.
Absolutely.
So we are moving right along here. For our small business owners, we've talked extensively about employment law principles and about the added protections for employees under the FFCRA. So if you are struggling to make ends meet, to make payroll, I want you to check out my YouTube video on Paycheck Protection Program. It's one of the newer protections that have been provided for small business owners. And it's technically a loan that you can apply for, and it may actually be forgiven later if you use more than 25% of it on payroll costs. So go ahead to my YouTube channel, SL DeBarros Law Firm, and find that so that you can educate yourself and see if you are eligible to apply for this particular program. Andre Gaston, thank you so much for being here today with us and talking employment law. I know this is your bread and butter type of area. I mean, you are a legal genius, especially when it comes to employment law. And it's such a pleasure knowing you, being in a professional relationship with you, and being able to bounce ideas off from you, on just a regular basis. So I definitely appreciate you as a person and as a professional.
Listen, I have to tell you that I know a lot of lawyers, and you continue to amaze me with all of the successes that you're having in state and federal court. I'm your mentor, and I look up to you. So you are just really killing it, and being a mom and being a wife and being a great advocate. I certainly enjoy all of the times and thinking about you and how you think about things from a top-down perspective. Sometimes you amaze me just talking about constitutional law. And so maybe I'm just looking at case law, and then you'll talk about the 14th Amendment or the Fourth Amendment. And I'm like, I'm a subject matter expert in employment law, but I didn't even think about it that way. So I'm so proud of you and happy that you continue to provide this information for people so that they can become more educated about their rights. And ultimately, that's what we're here for, to try to help these people get the justice they deserve in the event that their employer violates their rights. And I'm really happy about
Absolutely. Thank you so much. Thank you so much. And you can find Andre Gaston online at his website at gastonllp.com. If you want to connect with him, you can also submit a contact form, which is on his homepage on the website. You can connect with him on social media through Facebook, LinkedIn, and YouTube. I am Savani DeBarros. It's been such a pleasure to bring this webinar to you today on Can My Employer Terminate Me During COVID-19? You can find me at sldebarros.com. If you have any questions about this webinar, any other webinars that I've done, shoot me a quick email at sdebarros@sldebarros.com. Connect with me on Twitter, Facebook, LinkedIn, YouTube, and Instagram. See you guys later in the digital world. Have a great day.